Good evening and welcome to our 2023 Estate Planning Webinar. My name is Kevin Johannes and I am the Director of Communications for the National Council of Negro Women. I am honored to be your host and moderator this evening. I am taking the place of our normal moderator and host, Miss Janice Mathis, because she happens to be at a program where she's honored tonight. So I'm fortunate enough that I can try to fill her shoes, the flat ones, not the high heel. And I am here with three great and intelligent and knowledgeable people. As I've looked at their PowerPoints as a sneak peek, so I know that you're in for a treat. I'm going to say their names and hopefully I get them all correctly. Mr. Jamie Burrow, who's down in Florida and DC. You go back and forth, sir. Ms. Amy Griffin, who handles the DMV area. And Ms. Cheryl Wilkins, who's with New York Life Insurance Company. And you know New York Life Insurance is everywhere. So welcome, everybody. How are you doing?
Great, thank you.
Doing well, thank you.
Fantastic. Because we have a lot to cover, we're going to get started right off the top. And I'm going to turn it over to Ms. Wilkins, and she'll be able to show you her PowerPoint. But before we do that, I want to make sure you know that we will have a question and answer period at the end. Please make your questions direct and succinct, as we're going to read them back to our panelists so that they can answer. And there you are, Ms. Wilkins, you have control.
Wonderful, thank you very much, Kevin. And good evening, everyone. Get things going here, my apologies. Computer's decided to run slow right now. So I have to do my little legal disclaimer. Anything I share with you today is just for information only. This is not advice. I'm not giving you tax, legal, or other advice this evening. Although I am licensed to provide consultation in various states. I don't know where you are, so I'm not giving you advice right now. Why is estate planning important? I'm not going to go through all of these bullet points. We have a lot to cover today. But I do want to make sure that everyone understands that we're not estate planning just in the event of our death. One of the things that I share with people often is an attorney that I work with in Indiana says that one should have an estate plan as soon as you turn 18. We send our children off to college, for example, and where many of us, our parents were still able to make medical decisions for us when we were 18, HIPAA laws have changed such that when we send our children off to school, although we may still be responsible financially for their medical care, we can't make decisions for them anymore. So they should actually have an estate plan, because your estate plan includes things like your living will, your advance directives. So everyone should have an estate plan so that they can make their wishes known, not only for what happens once they're deceased, but what they want to happen when they can't make decisions for themselves, what should happen to their estate, and who should be guardians for their children. I mean, there are a multitude of things that you are indicating in that estate plan. So everyone, once they're of age and are making decisions for themselves, should have an estate plan for a variety of reasons. Okay, oops, there is a lag. So why? Again, very, very, very many reasons why it's important for a variety of people. I'm not going to hit on all of these, but again, just things that sometimes people don't think about. For example, if you have a loved one, whether that's a child or a sibling, but anyone who you are responsible for, who has special needs. An example that a lot of people were unaware of, including me. Aretha Franklin had a special needs son who was living in California when she died without an estate plan, who was receiving services from the state of California. When her estate is finally settled and that child receives his portion, it's not a child, when that son receives his portion of her estate, it likely will blow up his services from the state of California. This would be true from anyone who has someone they love who is receiving services provided by the state. When that person doesn't own anything, the state provides those services free of charge, right? But if you suddenly have assets, the state looks and says, well, wait, why are we doing that for free? You can afford to pay for them. And where you want those assets to be there to ensure that when you're no longer there, they are able to live the lifestyle to which you want them to be maintained. Instead, now those assets are being consumed to pay for the services that they have been receiving for free. So if you have an estate plan and you plan well, you put in place a special needs trust to take care of them, right? But not to pay for those services that have been rendered for free. So there are just a multitude of reasons why you need to plan, not just to leave assets in the way that we typically think of them. Want to kind of highlight the importance of planning using two families that many of us have heard of, and go a little American history, the Rockefellers and the Vanderbilts. But before we talk about them, I want to share a little research that NASDAQ did several years ago, and I don't believe that there's anything that says this has changed. Their research showed that when we pass on wealth, the second generation that receives that wealth, 70% of the wealth is lost in that second generation. So if I pass wealth to the next generation, to my son, for example, he will lose 70% of it. He passes it on to the next generation, and third generation, 90% of the wealth is gone. So 90% of it never makes it to the fourth generation. Doesn't matter the size of the wealth. So now let's look at the Rockefellers and the Vanderbilts, see if that holds out to be true. Most of us recognize that John D. Rockefeller made his money in oil, right? He left billions of dollars to his family. Counterpart, Cornelius Vanderbilt, about 35 years older than John D. Rockefeller, made his money in shipping and the railroads. When he died, he was the oldest the wealthiest man in the United States. He left his money. In 2017, David Rockefeller, who was the grandson of John D. Rockefeller, died at 101, was the world's oldest billionaire, worth $3.3 billion. 2 years later, Gloria Vanderbilt, who was the great-great-great-granddaughter of Cornelius Vanderbilt, died and left her son $1.5 million. Big difference. What was the difference between those? I'd offer to you the biggest difference is there was a plan in one place and not in the other. The Rockefeller family had an incredible estate plan, including a family constitution and a series of irrevocable trust. And what that means is no individual in the family could tear apart the plan. So none of John D. Rockefeller's descendants could decide they knew better and could say, nah, I don't want to do it that way, because those irrevocable trusts were impenetrable to one individual. A lot of people have heard that the Rockefellers made their millions with these insurance policies. Well, obviously they made their money in oil, and then they built it and expanded it with other business investments. But it is true that there are trusts that fund and they continue to fund life insurance policies. So when members of the family die, the death benefits go back into the trust to purchase life insurance policies on other members of the family. And that money can be used to fund other business interests, right? So the family can use those funds according to the rules of the trust, and it just perpetuates. So that is a part of it. It's not everything, but it is a part of how they continue to make money. Because by the way, that money is tax-free. and it has been going on for generations. Now, given the size of their fortune, without question, they're also using other wonderful, sophisticated estate planning and tax advantaged strategies. The Vanderbilts, Cornelius left the bulk of his estate to one of his children. That son then gave some of his siblings some money because he didn't want to hear them complain, but he then decided how he would leave money to his children. And there was no cohesive plan that was safeguarded against any irresponsible member of the family. And so the money was frittered away by bad business decisions, by lifestyle choices, and it just didn't sustain multiple generations. Gloria Vanderbilt, again, was the great, great, great. She was the fifth generation, 1.5 million. The fifth generation after John Rockefeller, still living and still has billions of dollars to their names. The difference is a plan. And what's in the plan? Variety of pieces to it, very complex. Now, I work with people all phases of life, and we kind of like to use a house or a pyramid to depict that. But those phases we kind of call the protection plan. I tell people that's not the sexy part. That's why I like the house in that illustration, because that's, when you're building that foundation, very few people, if you've ever built a house, very few people invite people over when they pour the foundation and talk about, look at this wonderful foundation. People don't get excited about the concrete, right? But as soon as they start putting those 2x4s up, people will invite you over, right? We're standing in my living room. No, we're standing on concrete with 2x4s. But that excites people. That's the accumulation phase, right? When they start framing the house, people get excited. That's the accumulation phase. When you start accumulating assets, when you start accumulating wealth. And when they put the roof on, that's the preservation phase. I've accumulated wealth. How do I preserve it? How do I make sure that it does not run out before I do? And how do I make sure there's enough to leave to those beyond me, or to charity, or whatever my plan is beyond me? All right. Now, pyramid is used in a lot of different ways for a lot of different uses, not just in financial planning. And I would offer you the reason that is because, of course, it is also the Greek symbol for change. So we're planning a change. And then I also wanted to use this to point out a plan doesn't happen one time. You don't do an estate plan, put it on a shelf and go away, because life changes. You may have more children, or you may have another business that you build. You may change your investments. Life changes, so you should always revisit your estate plan. And what's in the estate plan? It's also your financial plan for living, because again, it changes, right? So the things that you should include should reflect what you're doing to live and fund your living. Looking at that pyramid again, that foundation starts off defensive. What do you own? What do you make? What do you owe? And who do you love? What are you doing to protect those people and to protect those things? The next level, you start planning, right, for the future, preparing for the future. You're making major purchases, you're buying houses, you're investing in businesses, you're building businesses, you're having children, and you're planning for their future, right? You're planning for your retirement, the next phase of your life. You're then building assets, right? You're diversifying your investments. You're maximizing your investments. You should be planning in that retirement planning for how do I not allow changes in tax code, changes in the market, changes in inflation to override my great planning of those assets. And then the last phase, want to make sure that I have planned again for how do I conserve my estate, not only for my lifetime, but those beyond me. I don't know what's going to happen with taxes. So I have to build a tax efficient. So I have to build diversification, not only in risk, but also in tax, so that I can sustain. Okay, so all of those things you're looking at, not just for your lifetime, but also in preparation for estate conservation. So the same things you're thinking about for your retirement planning, you should be thinking about when you're building your estate plan. So what is in your net worth? How are your assets composed? Because that then gets into what should be in your estate plan. You have your principal residence. If you left your house in your estate plan, you wouldn't be different than most people. Now, I put these in a particular order because if you look at the asset composition of the middle income level, right? That's those with a net worth up to $500,000 roughly. 69% of their net worth is their primary residence. If you have 3 children, 69% of your net worth is your home. How are you planning to share that with 3 children? And if you want that to go multiple generations, if you're truly trying to create generational wealth, which suggests more than one generation, how do you make 69% of your net worth being your home last for multiple generations? The next biggest chunk of that middle income group's assets are their retirement assets. And if you look at it, most people's retirement assets are in qualified retirement assets. That's tax deferred, your 401ks, your IRAs. Again, what you have to think about there is the only person that you can just retitle your tax deferred retirement assets to is your spouse. They can just move those into their name. If you leave them to anyone else, they have to go into an inherited IRA. And in 2020, our federal government got rid of the stretch treatment for tax deferred assets. So when they go into an inherited IRA, the recipient has 10 years to take them out and pay taxes on them. If we do live to our natural age, right, we die at a ripe old age, then our children, for example, are likely going to be in their highest income earning years when they inherit those assets. So they have 10 years to distribute them, layer them on top of their high earning years, push themselves up to even higher tax brackets and pay taxes, higher taxes, not just on what you left them, but on what they're already earning. Not the most tax efficient way to create that generational wealth. My point being, we really do have to be thoughtful about the composition as we're planning for our life and beyond. As we think about how we compose, and it just so happens, by the way, that if you think about an integrated retirement income strategy, you should be thinking about those same things. There is a white paper out there written by Wade Pfau, who used to be a professor at the American College of Financial Planning, who said that a great strategy for retirement is a combination of assets in the market. That would be, again, our qualified retirement assets. Usually those are in stocks and bonds. Guaranteed income. That used to be pensions when those existed. Now we have to replace those often with our own self-created pensions, which would be an income annuity, for example, and cash value life insurance. Most people don't think about that as a part of a retirement income strategy. But you can use the cash value of a life insurance policy as tax-free income. Helps you hedge your tax exposure, since we don't know what's going to happen to tax rates, for example. It also allows you, if the market is down, to pull money out of your cash value life insurance and not pull any more out of the market than you have to, baking those losses in, eating through your assets faster. So it gives you some flexibility in how you hedge some risk. And there's a lot that you could look at in that paper. You can actually Google Wade Fowl and see lots of publications he's done. He's written books about these things as well. But that's something you could think about from a retirement standpoint. And the other thing he also happens to mention is that that would also help you with estate planning and legacy planning. So things to think about. My 10 minutes are up.
Why, thank you. That was very insightful and gave me some things to think about. We've already got a couple questions for you, and we'll get to most of them at the end. However, one person did ask, is there a book on the Rockefeller estate that you would recommend?
Ooh, great question. I do not know, but there is another book that I will look up the title and share that talks about how many, including Walt Disney and J.C. Penney, used life insurance in their business strategies. So I will pull that up for you because I know it's easy to find on Amazon, for example.
Fantastic. So we're going to continue. Ms. Griffin, I'm going to turn it over to you because I know that you have a lot of enlightening information as well.
Excellent, excellent. I thank you. I am going to share my screen, and I always apologize in advance because my technology challenges tend to be consistent. Okay, so I always start off with sharing a picture of my team. You can see my screen, correct?
Yes, we can.
Okay. So I always start off by showing a picture of my team because we operate as a team. And I also encourage people that when you are selecting an estate planning attorney, wherever you are, be thoughtful about making sure that your values are consistent with the values of your estate planning attorney, because your relationship is an intimate relationship. And so making sure that you align so that you feel comfortable having the conversations, you're comfortable sharing with them what you would want to see, as well as in that knowing that they can hear you, as opposed to many times we've had folks tell us about how they've had people with whom they've spoken who did not hear them or did not see them. So I always say we operate in a team. Our core values are faith, excellence, relationship, service, and trustworthiness. So make sure when you move forward with someone that you are mindful as to who you're talking to and that they are aligned with you. Okay. Okay, wait a minute, trying to figure out now. Okay, and so estate planning, and I'm going to be quick because I think that Cheryl shared a lot of the things that I would talk about, but estate planning is a holistic approach to determining how you want all of your life to be lived and your assets to be distributed, not just during your lifetime, but when you pass away. But how do you want to create this significant plan in charitable giving? How do you want to make sure that your lifestyle is such that you're not just your lifestyle, but your children's lifestyle, and your children's children? How do you want to support that? And so impacting multiple generations to build wealth. What we know is if we just plan for this week, it's typically because we can only just live from paycheck to paycheck. But if we can raise our vision, raise our sights to multiple generations, we can impact our community and our loved ones. And I always talk to people about, I'm a big person of faith, as I said, that a good person leaves inheritance for your children's children. And I encourage people to not think about that as your biological children, but think about that as your community children, your spiritual children, your just people that you just may have adopted along the way without legally adopting. So I encourage you to be thinking about how do we support people to go from the position they are to the place you want them to be. I think there's a book that's called What the Rockefellers Did. And that, I think, there's a lot of that information that was shared earlier. But there is this constant thinking about, if I'm just planning for my children, what happens. I've had many people say to me, oh, they'll be grown, they can do what they want. But we get to be strategic. We get to be building out what we want to look like. How do we want to set them up for the future? Again, the Rockefellers versus the Vanderbilts. When the Rockefellers were able to create the tools and the resources, and the Vanderbilts were not. Then, again, the pyramid. First and foremost is that foundational. planning for incapacity, planning for what happens if something's not okay, but then making sure that your family is okay. Be thinking about how do we are able to build now, not just for our family, but for our family personal resources, but our business succession planning. How do we think about that? How do we do our exit planning? How do we think about making sure that our children and our children's children have enough education? But then what is really important, as well as what we say in our firm, is that strong families make strong communities. So at the pinnacle of the pyramid, not just planning for you, not just planning for your children, but planning for your community as well, as to give back. And when I say that, I'm very mindful about that, because it's not just it's not just always just altruistic, but it's also strategic planning as well. So we encourage people to be thinking about how do we sometimes mitigate that, because as we plan, as our firm plans, we are very thoughtful about multi-generational wealth building. And so with that, we create income producing considerations. Therefore, sometimes we're charitable, not just because it's good, but it's good for us when we're talking about how do we mitigate taxes. So I encourage people to be thinking about that in a holistic approach. And then, much like the Rockefellers, thinking about strategic legacy planning. So if I have $1 million, I'm just going to use numbers. Say lawyers, I say, are not the best mathematicians. So I encourage people to just think about, if I have kids and I have $1 million, I give each of my kids $500,000. They have 2 kids, so each of their kids get $250,000. They have 2 kids, their kids get $150,000. So we will, by disseminating the dollars, we're going to run out of money. But if we centralize it to say, okay, we have a fund of $1 million, and how do we strategically build together to create plans for rules that not only that we can disseminate just a portion of the income, but how can we build it such that we are not just sending or separating our families, but we're bringing them together to create family enterprises. That's part of the strategic legacy planning I encourage people to be thinking about. Not decentralizing your assets, but centralizing it with a mission, as the Rockefellers did with a constitution. But I'm saying, let's create an enterprise so that we can build wealth for multiple generations, right? And also mentioned thinking about that real property. Now, one of the things that we know that in the Black community, we are losing real property generation after generation. A lot of times people are complaining about the gentrification, but if we don't plan, if we don't think about what's going to happen in a longer term, like we have a matter now where a mom left her 4 kids a house. And what happens when you leave 4 kids at the house? 1 kid wants their fair share at least. And so as opposed to making that income producing property where you can make distributions from the income, the house is often sold because I want my fair share of that. But we need to be thinking about, what does that happen? Now, I always encourage people to be thinking holistically about how do we create a legacy, because I want folks to have as much land as possible, because that's, again, I say real property appreciates, money evaporates. So and I can tell you stories about what happens when people have gotten that huge chunk of money. We know inheritance is a lot like a lottery winning. And we know there are reality shows about the lottery winners and how they are 4 times more apt to file bankruptcy. So I encourage people to be thinking about, how do we preserve and protect the real property that we have? And one of the things that I encourage people to be thinking about, if you have a blended family, to be very thoughtful about how do we preserve that the assets for the benefit of the spouse, but as well as thinking about, if we have separate kids, how do we make sure that everybody is honored and everybody is respected? And then the one warning I want you to hear is, I tell people all the time that don't put your kid's name on your deed for your real property. I can tell you that there are many reasons why, but one of which is when we think about the capital gains, many people hear capital gains but don't necessarily understand what it is. But capital gains is when you have an asset, appreciating asset. The gain is the difference in what you bought it for and what you sell it for. Now, I use my favorite former next door neighbor, and they bought in Washington, D.C. They bought the house for $17,000. And now the house is worth $717,000. If they were to sell the house, they would have to pay capital gains on the difference between what they bought it for and what they sold it for. And that in this example would be $700,000. If you put your kid's name on the deed, it's as if the kid bought it for $17,000. And so they don't get what we like to give people is a step up in tax basis. And so if you were to transfer the house upon passing or in a trust, then they get a step up in tax basis. And so it's as if they purchased it at the fair market value at the time of the transfer. And it's sort of confusing, but I encourage people at least to know that I said, don't put your kid's name on the deed most of the time. There are rare times when I say that it makes sense, but typically don't do it. All right. And so so what we know is the joint tenancy with right of survivorship is what I call the last man standing law. That means, so if my husband and I own property together and he dies first, then it's now, and now it's all mine. And then when I die, if I have no plan, it goes to my children. And so with that being said, we're a blended family. As I tell people, I'm third generation blend. If it goes to my children, that means his child doesn't have access. So I encourage you to be thinking about how do we make sure we honor and respect all of the relationships? Because if we don't have a plan, the government creates the plan for the formula for us that's distributed, and it's based on the state that we're in. And so I encourage people to be thinking about how do I preserve and protect that which is for the people that we care about. I will quickly talk about businesses because I happen to be at a business conference right now. And one of the things that we know about that, as your personal assets should have an estate plan, your business should as well. And what you do, what we encourage people to do is begin with the end in mind when you start a business. Many of us start a business and we are thoughtful about we're just creating a job, and we needed a job, so we created a business. But we have the opportunity to fix that and correct that, make sure that we have the appropriate entity for tax purposes, we have the appropriate entity for liability prevention. And what we talk about is the business succession planning is the 5 Ds in our firm. Planning for disability, divorce, departure, dissolution, and death. Knowing that all of those things need to be factored in, planned for, so that we can make sure that the business that we spent our life creating and worked so hard to protect, that our loved ones get the benefit as well. Now, I think this is it for me, and so that we can, I think that's all my 10 minutes, and so that we can go to Jamie.
Well, I'm first going to say thank you for that presentation. That was a lot, and you did it very quickly, but I will tell everybody that this is being recorded, and it will live on our NCNW YouTube page, as well as if you look in your handouts as the presentations are being done, a PDF version is also there. So don't worry, you can get the information. You don't have to take a whole bunch of notes. At the same time, I'm going to ask you one question that relates to you, Ms. Griffin, and that is someone asked if your firm was a fiduciary?
So attorneys are fiduciaries in their role as estate planners. Right? Once you become, once we act in that relationship, yes, we do. Now, we also, just as a FYI, we serve DC, Maryland, Virginia, New Jersey, Pennsylvania, and Massachusetts.
Fantastic. So at this point, I'm going to have our third presenter, Mr. Jamie Burrell, come on in and you can kick it on home for us.
Excellent, excellent. Here, let me just share my screen here.
There you go. We see your
Are you
screen.
able to see my? Excellent, excellent. Well, good evening, everyone. My name is Attorney Jamie Burrell. It's such a pleasure to be here speaking with you and to share this panel with Ms. Wilkins and Ms. Griffith. I'm very honored to do so. A little bit about background about myself. I am based out of Florida, licensed in both Florida and the District of Columbia. I hold an advanced law degree in taxation with a focus in estate planning. And finally, I am an adjunct professor at Inver Hills Community College teaching probate law, and I'm also an adjunct professor at law at Concord Law School. So tonight, it's hard to follow Miss Wilkins and Miss Griffin because they gave such thorough and helpful presentations. What I'd like to do is I'd like to discuss and focus more so on what happens if you do not have an estate plan, and essentially how your estate will pass, and essentially how your assets will be treated both during your life and after you've passed away. So some of the general estate planning goals that my colleagues had touched on, avoiding probate, asset protection, legacy planning, contingency planning, and even Medicaid planning, they are all important factors in your estate plan. And something someone told to me a while ago, which stuck with me, was not having a plan is having a plan to fail. So essentially, as Ms. Griffin stated, if you don't have an estate plan, the state will choose for you how your assets will be divvied up after you pass away. But not only that, the state will have a say in how your assets are treated during your lifetime if, God forbid, you were to become incapacitated. So first, I'd love to touch on probate basics. And for those of you that are not aware, probate is the process by which a court transfers your assets to the next generation, to your beneficiaries. And that can be done whether or not you have a will, because in many states, and I would say in the majority of states, having a will does not avoid the probate process. In fact, I like to tell my clients, think of a will as a roadmap for a probate judge. It's basically you telling the judge that these are your wishes for how your assets will pass. These are your wishes for who you'd like to be in charge of your estate after you've passed away. But still, it's going to need to go in front of a judge to get that final sign off. And another big part of probate law is wrapping up affairs after you've passed away, assuming you do not have a valid estate plan in place, right? So let's say, God forbid, you were to pass away at the hands of an individual or at the hands of an accident, right? Under normal circumstances, if you hadn't passed away, what would you do? You'd hire a personal injury attorney, and you'd go to the mat and you go to challenge that in court. But after you've passed away, it becomes incumbent upon your loved ones to move forward, open up a probate proceeding in probate court, and essentially become appointed to speak on behalf of your estate and then carry forward whatever lawsuits would have gone in place due to your injuries. So these are very important points to probate, why it exists, but a big part of why we want to avoid probate is because it comes with significant costs. It comes with significant time investments. So, for instance, opening a majority of states, depending on specifically if you're dealing with a larger estate, the courts will most likely require you to hire an attorney to assist you with administering that estate. And the reason for that is probate court comes with a lot of requirements, deadlines, specific paperwork that needs to be filed, accountings that need to be made to the court, inventories, notices that have to go out to the courts. So because of that, a lot of courts require you have an attorney, and that comes with attorney costs, court costs on top of that. And think for a minute about how long a regular court process might take. It could be very timely. In the state of Florida, just to give you an example, my probates that I administer for my clients, those will last typically around 6 to 9 months if you're working as efficiently as possible and there are no delays. And dealing with the court system, it's likely you'll come across delays, right? So like I was mentioning before, not having a plan is having a plan to fail. And by that, I don't want to sound too harsh, but essentially, as Ms. Griffin alluded to, when you pass away without a will, the state gets to choose how your assets go. And we call that intestate succession, right? That's your state determined estate planning. Your line of succession, as according to Florida law, is if you pass away with a spouse, your spouse inherits your estate. If you have no spouse, then it goes to your children. If you have no children, then next in line, your next of kin, so to speak, under Florida intestate succession laws, are your parents. After that, your siblings, and then after that, there is it continues down the line to different family members, no matter how far, no matter how remote, no matter whether or not you knew them, liked them, enjoyed their company or not, the state of Florida will pass your assets to them if you do not have anyone else in the line of succession. And finally, if you have no one to claim your estate, what's next is we call that escheating to the state, which essentially means that your assets will go to the state. The state will inherit your assets. So this all highlights why it is so important to make sure your wishes are written down as you are living. Because if you are in that rare circumstance where you don't have any immediate family members, making sure that you have everything in writing to say, hey, I want my friend to get my assets. I want my neighbor to get my assets. I want my charity to get my assets. If you don't have that in place, your state will choose for you where everything will go. Now, I mentioned before that having an estate plan in place is important because of incapacity planning, right? So estate planning is not just taking care of your assets after you pass away, it's taking care of your assets and yourself during your lifetime, right? And let's say, God forbid, you were to become incapacitated and you didn't have any plan for incapacity in place. Your loved ones would have to go to guardianship court in order to be appointed, and in some states they call them conservatorships, to be appointed as a person, as your guardian, as a person in charge of your day-to-day affairs. And for instance, under Florida law allows any interested person to come forward and petition a court to be your guardian in the instance that you are incapacitated. Now, interested person, how is that defined, right? It could be defined, it's defined a little loosely, if you ask me. So it could be your estranged daughter that comes forward and says, I'd like to be the guardian of my parent. It could be your estranged spouse that could come forward. So this is all the same, to make sure you have everything listed out in, let's say, a durable power of attorney, a designation of healthcare surrogate. Some states call them a healthcare directive document. It's important to have these wishes written down so that in the event that, God forbid, something were to happen to you to make you incapacitated, the person you trust and the person you know will take over to handle your conservatorship or your guardianship. And on the same note as the reasons why you would want to avoid probate, the same is true about guardianship. Guardianship is a court supervised process. It involves attorneys, it involves court costs, and it involves very intensive work, right? Making sure that the court is advised of all of the spending on all of your accounts, advised of how much income you're coming in. It imposes a lot of review by the state in the form of a judge, and you can avoid a lot of that if you just have your wishes planned out ahead of time. Now, I touched on the time and expense with regards to probate, but another point that I did want to mention was that creditors are part and parcel to your probate process. Probate, yes, it's the process by which your assets are officially transferred to the next generation if you had no probate avoiding plans in place, but also it's the opportunity for your creditors to have one final chance to get paid. So in the state of Florida, for instance, those who pass away, their creditors have a 2-year period, a 2-year window in order to come forward and be paid. However, with the guidance of a probate attorney here in the state of Florida, by opening up your probate process, what we would usually do, well, what we would always do, is publish notice to creditors in the local newspaper, which cuts that 2-year process down to 3 months. Creditors have 3 months in order to come forward and make a claim against the estate. If they don't make that claim within that 3-month period, then too bad, so sad, those creditors are not allowed under Florida law to continue to make any claims against the estate. So, and dealing with creditors at that time, it's very important to have a learned hand by your side to make sure that everything is taken care of, and that everyone is getting their dues. But it's a very big consideration, because if you avoid probate, you avoid that creditor process. Essentially, if you handle your assets in an appropriate manner, there'll be nothing for creditors to attach themselves to after you pass away, which is important in preserving your legacy and moving it on to the next generation. So some quick estate planning documents that I usually handle for my clients. A last will and testament, like I mentioned, that is the document by which you are giving the judge a play-by-play as to how you'd like your assets to pass. A trust, some of you may have heard of a revocable living trust or an irrevocable trust, but essentially a trust, think of it as a separate entity, like an LLC. And it'll hold and house your assets for you, and it can do so during your lifetime. But the funny thing about the law is, after you pass away, anything that's in the trust is not considered yours. So so for that reason, your estate will not need to go through probate, because there's nothing that needs to be transferred to the next generation. All that's already handled in the trust. I have on here a ladybird deed in Florida. It's not available in all states. Florida is one of the lucky states that have this as an opportunity for estate planning. The official name is an enhanced life estate deed. And essentially what it is you're transferring your home to yourself for your life with some certain reservations. So you're saying that you're still reserving the right to use, sell, mortgage, lease your property during your lifetime, but you're also putting in that after you pass away, you'd like the property to pass to another person, your beneficiary, for instance, your children. And by doing this, this is a probate avoidance strategy here in Florida, because after you pass away and you have a proper ladybird deed in place, your children can just go down to the county clerk's office, turn in your death certificate, and the county clerk will know to transfer ownership to your child. So it's a powerful tool. It comes with its pros and cons. I would highly encourage you reach out to an estate planning attorney in your area and your state to see if, one, this is an option for you, and two, if it's going to fit into your overall plan and your overall goals. I mentioned before a durable power of attorney. This is the document by which you give a third party power to handle your financial affairs. Make sure that when you choose a person, an agent for your durable power of attorney, that this is somebody you trust without a doubt, because these durable powers of attorney come with very strong powers for them to move your assets about and handle your affairs. But the main driving force of why we recommend these as estate planning attorneys is incapacity planning. If you were to become incapacitated, that person you designate will have the authority to be able to continue paying your bills and continue managing your affairs, and even help you apply for Medicaid if the time comes, depending on how your durable power of attorney is prepared. So if that is your goal, I would recommend specifically mentioning that to your estate planning attorney. A living will, there's many misconceptions about the term living will. It's confused with the last will and testament, but think of a living will as a do not resuscitate form. And you're essentially letting your healthcare providers know that in the case of terminal illness, vegetative state, you do not want life prolonging measures. So no ventilator, no respirator, no feeding tubes, things like that. If that is your wish, I strongly encourage you letting your estate planning know, so estate planning attorney know, so that you can go ahead and make sure that is properly included in your plan. Designation of healthcare surrogate, healthcare directive document, that is going to be you specifically saying, just like a power of attorney, but for healthcare needs. So somebody to be able to make decisions on your behalf if you're incapacitated. And finally, declaration of preneed guardian. Check state by state will have this. In Florida, we do. And that's essentially a form where you're stating, if I become incapacitated and I absolutely need a guardian, this is the person who I'd like that to be. So like I was mentioning or alluding to, having an estate plan is having a plan for all of these things. And I believe my time is up.
Well, that was
So
a
thank you
lot
for
of.
having me.
Thank you, sir. I'd ask that everyone come back to the screen, because these questions are going to go almost rapid fire, but they're all, wow, there are a lot of questions, but I think I tried to narrow them down while we were off camera. Starting with, if I don't have a spouse and kids, where does my tax deferment money go? I always assumed that it went to my benefactor.
Yes, so so the tax treatment is different if it goes to your spouse, but it still goes to your beneficiary.
Yes, you still
Okay.
determine who it goes to. You just have to, again, recognize that whomever you leave it to other than your spouse has 10 years to take those distributions.
All right. Next question is, what type of things go into a family constitution?
That's a very unique thing. Whatever you want it to.
So one of the
Okay.
things that we do is identify what are the standards, what are the values, what are the goals. And so each family is absolutely different. Each family gets to create whatever it is they want in their rules to sustain, how they want to move forward, right? It could be charitable giving, it could be education, it could be, how they invest. And so they get to create the rules for their own constitution.
Oh, interesting. So this person asked, I have 80-year-old parents who have life insurance that will handle the burial, but not assets other than the home. What is the best way to transfer the home to the surviving children?
You ask a lawyer any question, the answer is always, it depends.
Full disclosure, my mother's a lawyer, and I almost knew what that answer was going to be.
Yes, it kind of starts with, what do they want to happen to the home?
But as well as what are the things that we are guarding against? Like, I know that if we're concerned about, if their assets are limited and they're concerned about potential Medicaid concerns, that's one thing we're trying to protect against, So again, that's why the answer is such it depends kind of thing. We know that we want to avoid probate. That's one of the things that we're guaranteed to know. But beyond that, the next question is like,
Okay, here's one specific to NCNW members. Can you discuss why this topic is most important to women?
Ooh. I'll take that from a financial standpoint. One of the things that I find in conversations with couples, so I'll do that first. And let me say, I'm going to answer this in a very different way than maybe Amy would as a married woman. I am a single woman. But as I talk to couples, I think we have to, if we just look at statistics, women will be the last one standing. So often I need women to understand, and still to this day, often women aren't as engaged in the entire picture and I still find this very interesting. Women often are making decisions in the house, right? They decide who sees what doctor, they decide so much, but still are taking a co-pilot seat in a lot of financial decisions. But they're going to be the last one standing. Women are more likely to outlive their spouses. So we need to take a much bigger role in what are the decisions that are being made for how we're structuring our assets to last the length of our collective lives, since I'm likely going to be the second one standing. And then often women have very different feelings about what the legacy plan should be. So you've got to weigh in.
Okay.
I'm gonna, let me, I just want to
Please
say,
go
as a
ahead.
married woman, if my husband, if the assets were in his name and he died first, that's a problem. If, however, as a married woman, if I died first and then Anna Nicole shows up, I don't want our
Ooh.
kids to be out either. So that's the other piece. So
Mm.
Yes, the blended family part is, I'll give you a great example. I met with a couple in their late 60s, early 70s, and they'd been married for many, many years, but it was a blended family. And he just didn't want to deal with the drama, was what she said. She had been for years trying to get him to do estate planning, and he just didn't want to deal with the drama. And it just so happens he was a pastor.
Oh,
And so I said, you have to, and again, I'm a single woman. And so I started with, I'm not married. I've not dealt with, but I am a child of divorce, who one of my parents was a child of divorce, one was not. But I said, look, he's a pastor. He understands protect and provide. And you all have moved to a state. I don't know what the rules were in the state you lived in, but I can tell you what the rules are in the state you live in now. If he dies without a will, and you've told me your stepchildren don't even come to visit you in this state, but in this state that you live in, if he dies intestate and this house is not in both of your names, if it's in his, in this state, you and your stepchildren will jointly own the house you live in. Is he going to be okay with that? As a protector and provider, is he going to be okay that he left you in that situation? And she said, oh, now that's a good question. And so that was a question that kind of, after 20 some odd years, got her in a place where she could get him to talk about it and maybe get him to an attorney.
Mm.
So it's just, that blended family thing does raise a lot of questions. So yeah, it's
Okay, so
unique to women.
This next question, I know almost the answer is going to be, it depends, but it needs to be asked. Can you give a median range on how much it costs to utilize an estate planning attorney?
my first response to that always is cost versus value. Let's start there, right? And so you can download documents online and get a really low cost. Right? You get no advice, you get no guidance, but you get a really low cost. So I encourage people to be thinking about what happens if you don't pay anything as well. And then as Jamie spoke about the great cost, my brother is an attorney, and he was told, don't charge anybody for wills whatsoever. You'll make a whole lot of money in the end. So again, because the probate costs are so significant, so you get the benefit. And I will say that there is, again, it depends based on what services you're providing, what that you're seeking. But Jamie, you can build on that as well.
Well, yeah, to build off of that, I probably add, as harsh as it might sound, you get what you pay for. So if not to knock any of my, brothers and sisters, brother and sister attorneys out there who maybe have a great bankruptcy or a great family law firm and they might do estate planning on the side, be mindful of going to a practitioner who is learned in all of the ins and outs of estate planning. And yes, that may come with a different type of cost, but you want to look at the cost and risk analysis there. And at the end of the day, if you have a plan that you don't understand and which may hopefully not doesn't stand up to the muster of the law at the time at the time you pass away, your loved ones may be stuck with a larger legal bill than necessary. So just keep that in mind when you're choosing your attorney.
Good. Okay, so this is an interesting question. How do we teach our children estate planning, and how do we get them to grow the wealth that we leave them?
Again, we lead by example. So I always ask those people say all the time, how do I get my parents in? I said, well, is your estate plan done? Right. So it's something that if we live with an example, just show most people whose parents have an estate plan, a significant one, a comprehensive one, also have learned to do it as well. We live, our people modeled the best behavior and the best practices. So we don't want people to continue to learn from the tragedies that happen.
The other thing I would share in there, I didn't share, the NASDAQ study went on to speak to why that loss of wealth occurs. And the very first thing they said was because we don't talk about money. We don't talk about money in our families. We do not teach our children about money. The second point is because we're afraid if we tell our children about what we've earned, they'll be lazy and won't go out and earn their own. And then the third point they make is I shouldn't say unfortunately, but it just so happens that not everyone who makes money, who earned and saved money, really understands money. So they don't know how to teach the next generation about money because they just happen to earn it and save it, right? So we have to make sure we've educated ourselves and then talk about it. That's one of the things as I do financial literacy classes, it's one of the first things I talk about. I mean, if we really think about what did we learn at home? Did our parents talk about money at home? Did people sit around the table and talk about what do things cost? We certainly heard turn off those lights. I'm not made of money. Did anyone talk about how much the light bill cost relative to how much was made?
And to add to that, I think that there might be a level of superstition out there about talking about wealth and money, right? I come from a Caribbean background. My parents are from Haiti. And, I can tell you a lot of my family members, they don't want to talk about having a will because they think, hey, we're going to jinx ourselves. But, we need to find a way to step out of that and know that we need to set up the next generation for the better.
Yes.
We have the opportunity to create incentives and rules through estate planning, right? But if we don't, we get what we get, right?
One of our college members asks, do student loan debt go away when the borrower dies, or does it become the spouse's?
It goes away.
That's right. That's the thing. It's like we want to make sure, like I said, I want that in the casket next to me when I get cremated, right? The student loan bill, right? As long as it's not a parent, plus where they've co-signed, it's those things that are solely your debt. If you don't go through probate, and Jamie was really clear about, if you go through probate, that whoever your creditors get to come forward and try to attach your assets. But if you avoid probate, then that's not going to happen. It's going to say, oh, it's so sad. It's too bad, so sad is what Jamie said. Right?
If there's no estate for them to attach to.
I'm trying to figure out, we have a lot of questions and we're not going to get to, in fact, we're running over time. So I'm going to ask this question. Is an attorney necessary for estate planning, mainly for trust, or can somebody in the financial field be of assistance?
Can I plead for my attorney friends?
Sure.
I have clients and prospects who contact me and then they say, well, can you do X, Y, and Z? And the first thing I say is, I am not an attorney. And you do not want me or anyone else who is not an attorney to do those things for you. And I'm going to repeat what Jamie said earlier. You get what you pay for. You want specialists to do what they specialize in. So yes, you don't have to, but you want to have an attorney do those things for you.
Well, it is 6 past the hour. We were supposed to wrap up a few minutes ago. This was a lot of information, and I thank you all for coming to this estate planning for 2023. Again, everyone, if you missed it or if you want to share it with your friends, it will be on our NCNW YouTube page. We'll connect it to our website, as well as there'll be a survey that will go out at the end. I ask that if you aren't a member of NCNW, consider. Thank you, our attorneys and our life insurance people that were here tonight. Ms. Griffin, Ms. Wilkins, Mr. Burrow, thank you again. Have a great night.
Thank
Thank
you.
you.
Thank you for having me.